Hi.
Please, Lordships and your Ladyship, I appear on behalf of the appellant, together with my junior Mr. Jesse Nichols. For HM Assistant Coroner is Mr. Jonathan Hoff, King's Counsel. For the DWP is Mr. Jonathan Dixie. Sitting just here is Mr. Pravin Fernando for Dr. Rahman. He hasn't made any written submissions, and I understand his position is neutral, and he's not going to make any oral submissions. Within the court also are the Assistant Coroner herself, Jo Wharton, is in court, as indeed is the deceased's mother, Joy Dove, and the claimant in proceedings, along with her son, Jamie Whiting.
Well, let us give our condolences. It must be awful coming back to this year after year, but we'll never be able to put ourselves in your position, Mrs. Dove, but we do sympathise and understand why you're doing this case, and we wish you all the best with that.
Well, thank you very much. In terms of housekeeping, you should have skeletons from the parties who've written skeletons, as to say DWP, Assistant Coroner and ourselves, and you should have 2 bundles of authorities. You may also have received one additional document, namely the Chapter 13 of Jarvis on Coroners, to be added to the authorities bundle. Those are really the housekeeping matters. May I introduce the case by saying that by telling you what the structure of my submissions is going to be on the appeal, and then take it from there. What I propose to do, with your leave, is to look at some key matters of factual background, in particular the death and how it was recorded by the coroner, in other words, what happened at the inquest.
How would you like us to refer to Jodie? As Jodie, or Miss Whiting, or Miss Bell?
I think the answer is Jodie, please.
So we'll call Jodie then, if that's okay with Mrs. Dove. Yeah.
We'll look at the public record of inquest and see how the matter was dealt with by the Assistant Coroner in the first instance, and then look at the fresh inquest, because chronologically it makes sense to do so. And the 2 key bits of fresh, the ICE report and Dr. Turner's report, and then a couple of matters of public interest, which are referred to in one of the statements of Mary Varney about the interest generally in understanding the number of suicides arising from DWP failings and a certain amount of information about that. I will then address ground 1, in particular why the court was wrong to reach the conclusion it did, and where the 2 key points already identified in the grant of permission to appeal are unduly narrow approach and prejudging the issue that we say needs to be investigated. Those are the 2 key points on ground 1. Overall, our submission to you on ground 1 is that the court below were wrong to refuse the application for a fresh inquest on the ground that, in the light of the fresh evidence, it was both necessary and desirable. That's our case. On ground 2, we note the terms in which permission were granted, the some other compelling reason ground, but we do advance the argument that the court was wrong to conclude no arguable breach of Article 2, and as a matter of law, and you may have seen the way that Mr. Hoff puts it in his skeleton, our case is, as a matter of law, the Article 2 duty does arise, in this case, on its particular facts underlined, as I will come to develop. So with that being the general structure of the submissions, may I begin with some background facts, which in the light of the way that they're dealt with in the judgment already, I will deal with quite shortly. The deceased, Jodie Whiting, was 42 years old, a much-loved daughter, mother and grandmother, and she died from an overdose taken at her own hand on the 21st of February 2017. There were a number of handwritten notes found by her body, and those are recorded in the transcript of inquest, which is available to you and is in our core bundle at 315.
We have the notes and we have read them, and they're very sad and distressing reading, but we have read the notes.
I'm very grateful. As we've recited in our skeleton argument for this case, that inquest lasted some 37 minutes, and with a finding by the Assistant Coroner that she was satisfied beyond all reasonable doubt, and I don't think any issue turns on the change in burden of proof or anything, that this was a suicide. A public record of inquest, that document which used to be called the Inquisition, now called the Record of the Inquest, requires certain matters to be recorded. Indeed, there are 5 boxes, and we can turn it up in a moment, for recording the particulars, and the relevant document is to be found right at the back in the core bundle. The core bundles, I think it's the last page. 317 of the core bundle. And there, as you can see from that page, there are 5 sections for the recording of particulars. In box 1, name; box 2, the medical cause of death; box 3, the how, when and where, and in Article 2 cases, in what circumstances the deceased came by their death; and box 4, the conclusion of the coroner as to the death; and 5, the registration particulars as required by the Birth Cess and Registration Act 53. Now, I'll expand this point in due course, but just to be clear, I'm not seeking to raise some additional point here about insufficiency of inquiry, but I'm focusing the court's attention on the importance of the public record of inquest, and it is a factor that I suggest will be relevant to the discretion and the view as to whether it's necessary or desirable. On the completion of this box, may I simply refer, because it's helpfully summarised, to the Jarvis on Coroner's summary, and I printed chapter 13 because it is a, or if not the textbook that many practitioners use. I have put it, for the purposes of convenience, at the back of the second bundle of authorities if you have paper copies. You may have it loose. I'm sorry, it's such a to turn it up, and I'm going to try not to dot around.
Else, but I'll put it at the back, so if you tell me where it is next time, I'll also remember.
I think for convenience, and if it's acceptable to the court, may I, while we've got this open, refer you to the passages within it which I say are going to be relevant to the submissions I make, rather than dipping in and out, because it's quite unwieldy, all the bundles. The first passage is to be found at 13-03. After summarising the 5 boxes that I've just mentioned, the words appear in the final paragraph. It is critical that the facts found and recorded in 1, 2 and 3 disclose a factual basis for the conclusion in 4. If they do not, then that conclusion cannot be supported. There's some reference then to 13-25, which I'll come to in a moment. Although the registration particulars are included in the record of inquest, the statutory requirement to find and record them is technically separate from the obligation to make a determination. And the footnote tells you where you find that, and the simple answer is at 10.1b of the Coroners Act. And 10.1b of the Coroners Act in our bundles is reproduced. I'm not going to say actually that you necessarily need to turn it up, but it's to be found at the beginning of the first bundle of authorities, and 10.1b requires, 10 is entitled Determination and Findings to be Made. And 10.1 reads, after considering the evidence given to an inquest into the death, the senior coroner, if there's no jury, or the jury if there's one, must A, make a determination as to the questions in section 5.1a and b, and those questions are, one turns back 1 page in the bundle of authorities, who the deceased was, how, when and where the deceased came by his or her death, And if the particulars are repeated by 90 are required to be registered, make a finding as to those particulars. So separate obligations in respect of the registration particulars and in respect of the findings in respect of the who, where and how question. If I may keep, or if you've been able to keep that open, may I take you on now to 13-25 of the chapter, which is that passage dealing with, which was referred to in the footnote, about the how question. And it tells us at 13-25 that that's concerned with time, place and means or circumstances at or by or in which the deceased came by their death, and says various things about by what means in the Article 2 obligation, and recites the Chief Coroner's guidance, which we've got. That's guidance note 17, that's indented paragraph 18 about the three-stage process. I think we've reproduced that in our skeleton as well. Importantly, within that guidance, middle of the indented paragraph, box 4 is the conclusion, which must flow and be consistent with the earlier findings in as to 5A and B. And that's because coroners are entitled and in some cases obliged to analyse and give rulings or judgment as why they reach particular findings of fact and conclusions, and why they are or are not leaving particular findings. Then 1326 is about conclusion. It explains that conclusion may be one of the short form conclusions or a narrative conclusion, and it may be used in addition to a short form conclusion, may refer back to the facts on how, where and when. The better way, it says, is to record the mechanism of death in 3 and the wider but brief narrative in 4. A narrative conclusion is not confined to Article 2 cases, but is useful in other inquiries, for example, where the death results from 2 or more causes of different types. The point we pray and aid in our skeleton, and the footnote is the case we pray and aid Longfield, which I will come to. In general, a narrative conclusion should be used only where a combination of the answer to how and a short form conclusion is insufficient to seek out and record as many of the facts concerning the death as the public interest requires. And the reference to that, I think, is back to Thompson and Lord Lane, I think, in that case. The next passage, while we stay within this rather than coming back to it, is 1334. Before this chapter deals with what's called in inverted commas the official list. It's just about to deal with that in the chapter, and it explains that despite the existence of such an official list of suggested conclusions, there's no statutory requirement that the conclusions to death be in any particular form. All that's needed is it should be expressed in a concise and ordinary language so as to indicate how the deceased came by their death. And there's the guidance on conclusions referred to, that's guidance note 17, and it's to assist coroners at reaching conclusions, and gives guidance as to how to complete box 3 and 4. And we've got that guidance in our bundle, and just to say, if you're able to turn, for example, to our authorities bundle just a few pages before, 1209, paragraph 34, we have the guidance in non-Article 2 cases of a narrative conclusion being a brief, neutral, factual statement, not expressing any judgment or opinion, and the contrasting with Article 2 where the view can be judgmental. And an example is given for a non-Article 2 case on the following page, removing words such as missed opportunities or inadequate failures, but rather than, for example, saying there was a missed opportunity when the registrar failed to seek the advice of the consultant, the coroner could say, just as effectively, the evidence leads me to find that the registrar did not seek advice from the consultant who was nearby and available at the time, and the registrar knew that the registrar acted on his own. All that within an article, within a Jameson type inquest, recording the facts pertinent to the direct cause of the death. If I may then come back to and finish my little excursion into Jarvis, the next and final section that I would invite you to look at is that concerning suicide, and that is at 13-67. The literal nature of that word is explained. It is never to be presumed, but always based on some evidence. And it has two essential ingredients, and these are spelled out. And again, we've reproduced that in our skeleton in the guidance notes, that the deceased took their own life and they intended to do so. Intention, a necessary ingredient of the conclusion. Once there's sufficient evidence, it's a matter for the coroner whether or not it was suicide, and the conclusion won't be quashed unless no reasonable coroner, etc., could have found. And the test of sufficiency for evidence is whether other possible explanations have been totally ruled out. There's a passage about how it ceased to be a crime and so on. As to causation, it then says this at 69. The question of causation can be troublesome in suicide cases, and then it refers to, I think it's IBC and core vehicles, this case. In one civil case, the House of Lords held that where the claimant's husband was injured in an accident through defendant's negligence foreseeability causing depression, which caused him subsequently to commit suicide, the defendant was liable for damages, but it was still suicide. In another such case, Mr. Justice Blake held that where a young offender was subject to restraint a few hours before taking his own life, and his state of mind may have been affected by it, the coroner should have ruled on the lawfulness of the restraint and directed the jury accordingly. And then it continues, at least since 84, it's been consistently held in England that the standard of proof should be the same as in criminal prosecutions, and then we've got the valid standard of proof, and that's dealt with at 1370. And I'm not going to address you on that because that's not material. But at 1371 and 72, we have the wording. And we find this at 1372. The use of the additional words, the balance of his mind was, his or her mind was disturbed, which do not appear in the current rules, is still possible. Pausing there, earlier versions of Jarvis, going back 5-10 years, used to have that wording as quite common. But ought to be based on some evidence given to that effect at the inquest. So essentially, don't say it unless there's evidence, even though insufficient to negative the intention to take their own life. They do not imply any psychopathy, and for this reason it may be better to use a more explanatory phrase, such as, while suffering extreme anxiety and distress. But if the inquest on the basis of evidence finds that the deceased's mind was disturbed, then it is a finding that should be recorded. Other forms of words such as health harm, etc. Now, it won't escape your notice that the point I take from that is that in a potential fresh inquest, if there is the opportunity for a finding on evidence, in our case we're going to say Dr. Turner, that the deceased's mind was disturbed by the immediately preceding cessation of her benefits, that should be recorded as a finding on the public record of inquest. It doesn't have to be finding in judgmental terms. In fact, it can't be judgmental. It can't be an opinion. But a finding of fact to that effect is what should be recorded. If I now can just turn back to the facts, or rather just to make that final point about it should be recorded, is because the duty of a coroner in this hypothetical further inquest would be to seek out and record as many of the facts concerning as the death as the public interest requires. And so my case will be, at this fresh inquest, that the fact of causal relationship between abrupt cessation of benefits and death is a fact that should be recorded in the public interest. Now, as against the coroner and how she dealt with this inquest, we, the appellants, make no criticism. This is not a judicial review of any decision she made on scope. Neither do we criticise her for not recording findings of fact. She had no findings of fact about the ESA cessation, which were open to her. She had an opinion or a belief state expressed by, if I may call her Joy, but the deceased mother and her brother, and that was a belief. And she recorded, much as she said, she believes it was down to the cessation of benefits. That's all I can say, and I can't find any factual finding because there's no objective evidence on which I could find that. And we make no criticism of the coroner for that. But our cases, the fresh evidence changes the picture completely. And it is therefore to that fresh evidence that I turn. The fresh evidence consists in two, perhaps three pieces of information. I say perhaps three because it's only after death that the decision comes through that had this CAB letter been received, there was good cause for not attending the visit. So in other words, had that process been followed through, then, so that fact that there was, it's known after the event, in fact, good cause for not attending the work assessment meeting. So there are two pieces of new evidence, and those two new pieces are I'm going to call it the ICE report, maybe that's not a very happy phrase, but the ICE report and Dr. Turner's evidence. The ICE report, I'm sure that you will have read or seen the references to it. I don't want to laboriously read out passages of it.
We've read the whole report 3-4 times. I read it again this morning. It is sad and tragic reading with the missed opportunities.
Well, may I just, instead of reading out the passage, in the full knowledge of that, and that's simply to say that you see that it's set out in different sections within supplemental bundle at page 23, and it has a section near the beginning where it gives an account of facts at paragraphs. Can I just give you the paragraph number? I've said I'm not going to read it out, but paragraph 3. May I just try and briefly summarise rather than go through it laboriously? Paragraph 3 is a summary of the claims that she was making for incapacity and income support back in 2006 to 2012. Paragraph 5, it was already recorded she had severe mental health problems. At paragraph, a mental health flag was put on, paragraph 6. In 2014...
Jodie was put in the support group first, and that has its own consequences.
Yeah.
And then there's the mental health flag on top of that, so it's two things.
It's two things, indeed. My Lord, I appreciate. I'm trying not. You're absolutely right, and I'm not going to do it justice. But equally, I know that you've read it carefully. So
Well, this is a critical document, and we've read it, and we'll read it again, I imagine, before we give judgment. But certainly, if you want to take us to key things, yeah.
Key thing. Well, may I do that then? She was awarded the support group component for 24 months prior to reassessment. Paragraph 5. Paragraph 6. A mental health flag was raised on the DWP's referral to medical provider. That prompted a request for medical evidence. That required to be considered for a face-to-face. In August 2014, she completed a return and explained in her own words, most days I want to kill myself and my doctor doesn't get the pain under control ASAP, I plan to kill myself. And she found it distressing meeting other people and explained that as well. I'm not going to read out every line. And the GP confirmed the nature of her unstable personality since 1990. It was examined in 2014. She met the criteria for work-related due to her mental health status and was placed in the support group.
And she wasn't required at that stage to attend the face-to-face assessment because of her mental state.
Indeed.
Which had been described as constant stress, low mood and anxiety.
Indeed. It comes up for reassessment. She was in the support group till 17th of September. But in 2016, they said we're going to reassess and determine whether she still had limited capability and thus was entitled to be in the support group. They received a response. She stated clearly she needed a home visit as she rarely left the house due to mobility problems. And she stated she was seeing a psychiatrist and was suicidal a lot of the time and could not cope with work or looking for work. This was passed to the CHDA and a mental health flag was raised. And then it's described how when a claimant requests a home visit, the DWP should refer the request to the medical provider to consider the request, and there was no evidence that that was done. Paragraph 12, a further form was sent in November requesting evidence. The GP did provide evidence, and you see the detail, including she had previously been in hospital for intensive treatment due to suicidal thoughts. The GP thought she'd been discharged in June 2016, and she said she appeared to be making an effort to remain stable, and concluded by saying unable to comment on how her mental health impacted her daily living activities. And then on paragraph 13, she was required to attend a face-to-face assessment, and that letter was sent to her, and we get a bit more detail then. She failed to attend that assessment, and it's quite right to say there's no evidence that she attempted to contact them or to tell them she was unable to attend, and as it transpired, she'd not opened that letter. She was sent a good cause letter. You see that in paragraph 15. And there should then be an attempt, paragraph 16, but to telephone to establish why there'd been a non-attendance. And there should also be consideration of making a safeguard visit. Neither of those things happened. In other words, no call and no consideration of a safeguard visit. And then there's a further form issued asking to complete the form of the reasons why she'd failed. No attempt to telephone, or nor considering. And 18, she then completed the form saying she hadn't received it, and also said that her GP wanted the DWP to write to her, and the GP would give information about all of her illnesses. But the DWP did not contact Jodie's GP, and on it went. And finally, the decision was made on the 6th of February. She'd not shown good cause and was not treated as having limited capability, and therefore was no longer entitled to ESA. And the consequence of that, as is recorded in the judgment and as a practical consequence, all her entitlement benefits ceased. She lost housing benefit and everything else, and was effectively without any source of protection. She had a history of moving around properties in any event. The further findings that are important are then distilled out of those facts under the heading Additional Matters, paragraph 79 and onwards. And you can see how distressing it must have been for Mrs. Dove to read this document, because her complaint wasn't essentially about that. This came out of the investigation that had been conducted. Clear she was vulnerable, paragraph 80. She'd said she was suicidal. The DWP knew this, and that she'd been previously in the support group. And if followed their procedures, they put safeguards in place to ensure that these risk factors don't affect claimants or jeopardise their claims. So pausing there, and this will be relevant to both Ground 1 and Ground 2, knowledge of the suicidal risk and knowledge that there are procedures in place to reduce or mitigate or minimise that risk, to try and ensure those risk factors don't affect claimants. Paragraph 81 summarises what happened in September 2016 and the specific request for a home visit, which was effectively ignored. The apparent ignoring of the mental health flag within that paragraph. Notwithstanding the information that had been returned by the GP, a requirement to attend a face-to-face assessment. The fact that, again, clear guidance in place, paragraph 84, to try to safeguard vulnerable claimants, which says they're required to contact the claimant by telephone to establish why they've not attended the WCA whilst awaiting the return of the form. No evidence that there was any attempt of a phone call. And one sees that policy or practice in a freedom of information response that's made when the solicitors for Joy Dove write to the DWP and say, could you tell us what your procedures are? But that is the procedure. And it continues, the paragraph 85, they failed to write to Jodie's GP despite being aware that she was vulnerable, and you might also say she had a history of suicidal ideation. There was no annotation about mental health conditions before disallowing her claim. Indeed, it seems that wasn't considered at all, and that results in the phrase, concerningly, there's no evidence that they did so. In other words, annotated that they considered a mental health condition before disallowing. They did tell her about the decision. There was the ability for a mandatory reconsideration on the phone.
I'm looking at page 45. They're supposed to explain, aren't they? By recording findings about the claimant's state of health, whether the claimant is vulnerable. So if they're under a policy obligation to do that and they haven't done it, or there's no record of it, you would say it's a natural implication, therefore, that they haven't done it.
Indeed. And 87, following the disallowance of the decision, she was told to submit a mandatory reconsideration in writing. In fact, this could have been done over the telephone. In fact, pausing there, that would have been, I might have thought, given her conditions, the obvious way to work, and indeed in accordance with the guidance. She nonetheless did request a mandatory reconsideration 3 days later and asked that a new appointment was arranged for her. But sadly, she died 8 days later. No mandatory reconsideration had been completed, nor a further WCA arranged. And so, summarising, there were 5 opportunities for DWP processes to prompt particular consideration of a mental health status and give careful consideration to a case. None of these were taken. And then some points about redress. Now, in terms of the overall cumulative effect of those multiple failures was rightly described by the Divisional Court as shocking, as indeed undoubtedly they are. It is relevant to the case we bring both on ground 1 and ground 2 that there is guidance in existence for vulnerable persons which tells the DWP how to respond and gives them an approach. And some of that we've just summarised by looking at the ICE report. But helpfully, some of it is also distilled in a freedom of information response. And can I just give you the reference for that and turn it up? It's Mary Varney's statement at SB 72, where she summarises it, and then her exhibit, SB 82. So SB 72, is a passage of her statement dealing with applicable safeguarding policies. Towards the bottom of the page, she refers to various bits of guidance that she's been able to discover or find out from the DWP. And you see those listed at A to E. And under B in particular, I'll just show, because I'm going to show you this at the FOI, prior to a disallowance, DWP makes a decision assurance call to the customer. So it does indeed seem that before you abruptly terminate a whole suite of benefits to a vulnerable person, there is a requirement to make a decision assurance call to the customer. Of course, one of the main failings is that that was never done, and the response from the DWP on that is at page 82, where you see that reference, page 82, under in response to the questions that were asked. That is what she's referring to. At sub 3, about 2/3 of the way down, you see the words prior to a disallowance. And so on. And the confirmation at 7 of how mandatory reconsideration can be requested by letter or by telephone, and so on. So that's the point that short point, I suppose, we make upon guidance. And so, and the relevance of that, as I will later develop, is that there were reasonable steps available to the DWP to prevent or reduce the known risk of suicide of which they were aware. That's how that's going to slot into the argument in due course. The second piece of fresh evidence was Dr. Turner's evidence. Dr. Turner's evidence is at SB Supplemental Bundle 47 to 58. It commences at the bottom of the first page of that report by noting the concern of the family that the trigger was the DWP decision and the handling of the claim, and that was their concern, is their concern, clearly now with the benefit of the fresh evidence and the shocking failures revealed, an entirely justifiable concern, and records that there was no investigation into these issues, which, as we know from the inquest, there was not. And then it refers, as to her history, we see it paragraph 7 on page 50, the history of multiple overdoses in the notes going back as far as 92. And I simply raise that because obviously any coroner looking at the question of overdose and suicide, the family, part of their inquiry will be why now? Well, she'd overdosed before. Why did she form the intention to take her own life when she did? That's a human question to be asked by the family in the light of that history. Why was it so bad? Why was she so desperate to take her own life that she successfully completed that act? At 52 of the document, there's a summary at paragraph 12 of some evidence from Mrs. Dove, both about the unopened letter, about 3 lines down, and helping her to write a letter, and the consequence of receiving the letter that she was considered fit to work. So that's about 10 lines up from the bottom of page 52. She noted her daughter was shocked and distressed by this letter, crying and saying, "I can't breathe." Mrs. Dove tried to help Jodie deal with this, attending the CAB, and they were helped to write the letter. And Jodie also wrote a letter to her GP surgery, and finishing off that sentence. So she noted some of the notes handwritten by Jane outlining her desperation as to her financial situation. That's evident from a review of the notes themselves.
Have we seen the letter that she wrote, that Jodie wrote to the GP? Okay, it doesn't matter, but just in case I'd missed it, but we haven't missed it.
You haven't missed it, no. We haven't.
It's just a question, not a problem.
Yeah. At para 53, we've got the summary, last 3 lines of paragraph 13. I have suicidal thoughts a lot of the time, couldn't cope for work or looking for work, and that's recorded in the ICE report. And now there's a summary of some of the findings within that. At 54, we have some diagnostic matters dealt with, and long-standing history of psychological health problems, chronic pain, state depression, a presentation consistent with a borderline personality disorder, a subtype of emotionally unstable personality disorder, and then the relevant ICD-10 classification. And then some questions that are asked, and the doctor's answer to those. First question, what in your expert opinion is likely to be the impact on someone with a long history of physical and mental health problems, including history of taking overdoses, etc., who is reliant on welfare benefits, of having those benefits wrongly withdrawn? On the balance of probabilities, someone as vulnerable as Jodie would have experienced distress and shock at the withdrawal of her welfare benefits, given her ongoing difficulties, isolation, pain, and continuing emotional instability. Such individuals have an intense fear of abandonment, regularly suffer suicidal ideation, suicidal acts, and are especially prone, therefore, to disruptions in their social and personal life. This psychological sensitivity can be seen as being likely to generate a substantial depressive impact with activation of suicidal ideas and exacerbation of a negative sense of self.
Mr. Hyam, I wondered the extent to which that answer properly related to a question that was just to do with benefits being withdrawn, wrongly or rightly. In other words, she was somebody who was going to be precipitated into ill health by the withdrawal of benefits. I mean, the wrongness of it might come into subsequent answers.
Yes, I think one could delete the word wrongly with no diminishing of the relevance of the answer. The withdrawal of benefits was something which was likely to generate a substantial depressive input, whether it was right or wrong. That's the first point. But there's a reason why there are procedures in place to try and prevent an inappropriate or wrong decision being made.
I'm just trying to make sure that we've understood, and we're just trying to understand at this stage as best we can the doctor's views. If you withdraw benefits from somebody in Jodie's state, she would have experienced distress and shock. But you've got to read the rest of it, and what he's saying, I think, or have I got it wrong, is that, bear in mind, Jodie was somebody who had this diagnosis of personality disorder, borderline personality disorder, and was in chronic pain from the back condition and the other conditions we referred to. And that sensitivity, that's what the last sentence is saying, means that the shock and distress will be, I don't know, amplified might be a better word, or heightened.
By the underlying condition.
By the underlying condition. So the underlying condition will heighten the shock and distress that would be caused. That's a fair reading.
It is a fair reading. I don't want to use the phrase eggshell skull, but the point I'm trying to capture, or I think your Lordship is trying to capture there, is that underlying condition made her peculiarly vulnerable to extrinsic stressors. Maybe that's the wrong way of expressing, but that's the point.
Well, it heightened the effect. It heightened the effect of the distress.
The next question was, does your answer differ if the failings regarded to access to benefits specifically concerned failing to implement measures in place to protect vulnerable people? The failures to implement measures in place to protect vulnerable people would have exacerbated the emotional response, and overall my answer doesn't differ, but it's typical of someone who's highly vulnerable. Really, it's the same point, the exacerbating baited effect of the external stress of the withdrawal. do you consider that such negative decisions would or might cause a deterioration in the mental state of someone with the circumstances elicited at subparagraph A? On the balance of probabilities, Mrs. Whiting's vulnerabilities would have been substantially affected by the negative decisions outlined above, and a likely deterioration in mental state in terms of negative sense of self and a suicidal ideation, sense of abandonment intrinsic to the psychological condition of those with borderline personality would have been especially enhanced. Again, my Lordship's point about the underlying condition which exacerbates the consequence.
So stage by stage, her vulnerability would have been substantially affected. There would have been a likely deterioration in her mental state. And all of that is made worse because of her underlying medical conditions. That's a fair understanding of it.
It is,
yeah.
and her suicidal ideation would be exacerbated. Because he's saying, in terms of her negative sense and her suicidal ideation, it would have a negative effect on that.
The negative effect on vulnerabilities.
Yeah.
Deterioration of the mental state. And by mental state, he explains a negative sense of self and suicidal ideation, and that's going to be heightened or enhanced,
Indeed.
is his words, because of the underlying medical condition.
Exactly. And D, on the information currently available to you about Jodie, do you consider that there was a causal link between the failings outlined in the enclosed ICE report and Jodie's state of mind immediately before her death? Now, again, the wrongfulness perhaps put a line through, but what this is a psychiatrist analysing the effects of the consequence of those failings rather than the rightness or wrongness of those actions. On the balance of probabilities as outlined above, I consider there was likely to have been a causal link between the DWP failings outlined in the enclosed ICE report and Jodie's state of mind immediately before her death. A direct answer to the question posed, reproducing the same wording. This is based upon my understanding of the psychological effects of someone with a borderline personality disorder and chronic pain and the sense of isolation and abandonment that would have been reinforced by the DWP's failings. Again, certain circumstances, one could put a line through failings and say the cessation of benefits, and the addition of the word wrongful makes no difference. So those are the underlying bits of, that's the fresh evidence. So
But D seems to be really repeating C.
it is.
Yeah.
But it's a question that's been asked and
Yeah,
answered.
he answers it, yeah.
Yeah.
He's saying there's a clear link between a mental state, which he's already said is negative sense of self and suicidal ideation. There's a clear link between that and the cessation of benefits, and it's all enhanced or made worse because of her underlying mental health condition.
The words, he does confirm the immediately before death answer, and that's relevant to my submission as to directly causally linked. It's not something far up the chain, far upstream. It is relevant to the immediate means by which she came by her death. May I just finish then with the survey of facts before going to the law and submissions by dealing with public interest. Now, at paragraph, at supplemental bundle page 76, at paragraph 25, there's a reference to an exhibit which, for reasons of saving paper, did not make it into the bundles for this appeal. I'm going to tell you about it in brief as it relayed here because I'm not sure, but we've got a copy if it needs to be looked at. But the point that's made is that the National Auditor published a report in February 2020, and I'm not going to go without it in front of you, but it's safe to say Frank Field was key in asking a number of questions about DWP and suicides and the effect on benefits. And there were some answers, that the DWP since March 2016 had a single contact point for coroners, and that there were 19 contacts, 9 of which relate to suicide. The DW were unaware how many other contacts had been made via other routes, and the report acknowledged that DW investigated 69 deaths through suicide, claiming benefits, and it was highly unlikely to represent the full number of benefits deaths they could have investigated. And she then goes on to explain the parliamentary concern, refers again to those matters being raised in Parliament. The reason I mention that is because, and you'll see it from the next document, there's a genuine public interest and public concern about the risk of suicide for a particularly vulnerable group of benefits claimants. Not all benefits claimants, but a particularly vulnerable group of them. That's why there's the safeguarding guidance. That's why there's the vulnerability guidance. That's why the DWP has its own guidance referred to, I can take you to the document, on declarations of suicide and declarations of self-harm, where they have a 6-point plan to deal with it. That's why those are in place. But to finish the point about public interest, if I could please turn to a different inquest on different facts, another Jameson inquest, this time some man called Michael O'Sullivan. That's supplemental bundle, page 110. Now, he's a man who lived, I think, in Kentish Town at 9 College Yard. You see that at the top of the page, 110. And a narrative determination was reached in that case that he took his own life while suffering from anxiety and depression. The anxiety and depression were long-term problems, but the intense anxiety that triggered his suicide was caused by his recent assessment by the Department of Work and Pensions Benefits Agency as being fit for work, and his view of the likely consequences of that. Now, please understand me, I'm not saying, well, that this case, because this case, there must be a fresh inquest. But what I am saying is, if one looks at the PFD report that is then made, Prevention of Future Deaths, it shows that there is a legitimate public interest sufficiently concerning to this coroner to need to bring it to the attention of the authorities. And there is a public interest in such PFD reports being written, because unless they are written, there is no data that the DWP has about suicides and benefits, because unless they're using the single contact point coroners, which as we've just seen doesn't occur in every case, there's a lack of data as to how this matter, this kind of issue can occur. And the PFD that was written in that case at page 111 summarises the conclusion at box 3 that he took his own life by hanging while suffering anxiety and depression, and she made a narrative determination. And she found that a relevant circumstance of that was his recent assessment, and there were concerns raised by the coroner as to why certain things weren't done by the DWP in terms of assessment and safeguarding and so on.
The department will know about the failings in this case, because the ICE report says clearly
it does
the multiple failings. But you say that's not enough. You need a record in this form, because this is the data that will inform.
This is the data that
informs.
informs.
The data that will inform the overall response of the department to the way it's dealing with things.
Very much so. There's a real value to bringing it to public attention through a PFD report in a way that just doesn't happen if it's recorded as part of an ICE report.
Is it public attention or the department's attention?
Both.
Both. The DWP will know about it, but not in this form. And you say public attention generally ought to be aware of what has caused somebody to take their own life.
Indeed, and usually the way that matter might unfold in an inquest, and I should just say this now, just to be clear, because it said in the Assistant Coroner's skeleton that the appellant must be clear about what they're actually asking for in terms of this future inquest. Well, I can be very clear about that. It is an inquest that has as a matter of investigation, the causal link between cessation of benefits and the decision to take her own life. The witnesses for that will include Joy Dove, Dr. Turner, or any other psychiatrist who gives that evidence, but at the moment it's Dr. Turner's evidence, and somebody from the DWP, not to go through all the failings that are already recognised and accepted by the DWP, but to speak to what the policies and practices are at the DWP and address why, for example, a PFD report should not be written. Because commonly the experience in inquests is it's very common in a health case or in a prison case for a representative of the relevant body to come forward and say, yes, these things went wrong, we accept them, we've learned our lesson, we've put in place the following matters. There's no need for this matter to be raised more widely. At the moment, there is no evidence.
That would be a matter for the DWP if there's a new inquest.
That would.
So in terms of the 3 stages that we won't have to go through, the facts, because it's the facts that are relevant, and the facts are the cessation of benefits, but we also know the facts as to how that came about, because as I understand it, the DWP accept that the ICE report correctly records the events in question.
Indeed.
So that would be the evidence of fact. You wouldn't have to call people to ask about what do they fail to do, because it's all accepted as a matter of fact. Then you'd have the Turner report to see whether the coroner thinks that the abrupt cessation of benefits impacted on the mental health, and did that in turn impact on the suicide. It's quite a complex thing, because Jodie had quite a number of things going on in her life.
Agree, but a perfectly proper matter to investigate if it was the trigger event which formulated her intention to take her own life.
But a coroner may do a number of things. They may not put it in those terms. They may say the evidence, and you have to come back to Lord Justice Warby's decision, they may say the evidence doesn't show yet that it was this that caused the decision to take her own life. But you would say, I imagine, that it would still be open to a coroner to say there was an underlying health condition, there was then the refusal of benefits, and her health condition, which included suicidal ideation, itself became worse and was expected to become worse because of the cessation of benefits. So there are a variety of ways in which you say, I think, that the coroner could deal with it, and the coroner could take a different view if there wasn't a new
There are. I do say there are a variety of ways the coroner can deal with it, but I also say that the coroner could also, perfectly in the range of possible outcomes, the coroner could say, I find on the balance of probabilities that it had no causal effect. I cannot be satisfied in the balance of probabilities that this had causal effect. That in itself is a finding on a key matter explored at the inquest, which would be proper to record as part of the conclusion of the inquest. And I'll take you to a case where that is exactly what happens, where a key issue which is explored in Worthington is, and you may have seen in the case if you looked at that case, is whether or not there was a sexual assault, essentially. And the finding is no, that had no causal effect on the death. But nonetheless, the coroner said, I must still record it, because it's an important finding on a matter I've explored.
And would the coroner be able to say, or not say, Jameson, not Article 2, I don't think I need to go further than I have done, which is to say, Jodie, the medical cause of death was the taking of the overdose, and the way in which that came about was because she took her own life. Could the coroner stop there if it's a Jameson inquiry?
The answer is they could they? It is possible that the coroner could, but is it possible? Look, flip the other way on the Section 13 test. Is a different outcome in terms of narrative verdict, incorporating findings in relation to causation, a possible or even likely outcome? We say yes, it plainly is.
Yeah. I'm just going through, in my mind, the various things that you say the coroner could do, but one would be the coroner, rather than us, to say, well, I've decided that it's not necessary, despite the new evidence, to go further than the findings that I've made, yeah.
But repeatedly, you see in the Section 13 cases, the view expressed that it doesn't actually matter if the outcome
for us,
is the same.
If you're right that those four things could happen, particularly 1 and 2 could happen, that's enough. And then whether or not the department wants to say, we've learned our lesson this time, that'll be a matter for them.
It's a matter for them. There would be an issue. There would be probably a PIR, pre-inquest review, at which a decision would be made whether the DWP were to be made an interested party. It is likely, we suspect, that if the ICE report is going to be put in evidence, that a person from the DWP it's likely that the coroner would exercise his or her discretion to say, well, I'd like somebody from the DWP to come and speak, not necessarily the author of the report, but to speak to the department's policies and procedures in the light of the ICE report and what things have been done. It's a matter of the DWP, how they respond to that request, but that is certainly a real possibility, and we say likelihood is how that inquest would work.
Mr. Heim, can I just track back a little bit to the content of the hypothetical second inquest, should it go ahead? One of the things that you've discussed with my lord is the idea of the causal effect of the cessation of benefits. Do you need to break that down a little bit? Because something that doesn't appear to have happened so far in this case is a consideration of what causation must mean in a coronial inquest, and that what the coroner would be asking him or herself would be whether there was a material contribution or something more than minimal as a result of the cessation of benefits in the way the benefits were stopped. And so it would be open to you to argue, and to the coroner even to conclude that it doesn't matter whether the cessation of benefits was itself the trigger or not. That's not the question. The question is whether it fed into the deteriorating mental state which itself led this individual to take her own life. Is that right?
Milady, it is exactly right. In fact, I think we do, and I can't remember the paragraph in the skeleton where we mention it, but we do touch on the causation and the material contribution more than minimally. And that would be the discussion or the submission that would be made. You don't make submissions on the facts, but you are entitled to make a submission on the appropriate verdict. At the end of such an inquest, a likely approach would be that counsel for the family would urge upon the coroner a narrative verdict, and if there was more than minimal contribution by way of exacerbation of suicidal ideation or some such
that's what I was trying to get at. I mean, triggered the decision is the phrase that you've used. And I said the second option was affected the mental state, which my lady has put into more coronial terms, if you like. It may be that on Dr. Turner's evidence, a coroner may be able, the coroner, to say, well, there is a link between the deterioration in the mental state, but there's a lot of things going on in Jodie's life, but it made a contribution to the deterioration in the mental state, and then to go on and draw the conclusions of the mental state.
Indeed.
In its deteriorated state that led to the termination of life.
Indeed.
Or, as I said, no trigger, or the coroner could say, I don't need to go there. There would be 4 options, at least.
At least 4 options. I think for my purposes, I'm simply saying that don't prejudge what that coroner may or may not be able to include on the evidence that that coroner, he or she, hears. There is a real value in such an inquest taking place, both in the public interest, from Joy's interest, and in giving answer to a central issue that is raised by the fresh evidence. I mean, that's really my submission.
Then you have to show us that the court below was wrong to take a different view, and it may be they weren't wrong on some issues, but they might not have addressed, because the case has been put differently, other issues. But that will come to when you go
through the Divisional
Court decision. That's very helpful. Sorry to take you out of your order. We just wanted to clarify how you would think if there is another, because we haven't taken a decision, if there is another inquest, how it would work.
Indeed.
May I ask these questions that Dr. Turner considered? Presumably, was that your solicitors
I understand it was, yes,
Yeah.
they posed those questions to him.
So, particularly the last question, fairly deliberate, it would appear to me. Is there a causal link between what the DWP did and Jodie's mental state? So, not saying, was there a causal link between what the DWP did and the suicide, but was it something that added in to the whole mix of problems that faced her on the day of her death?
Well, may I address that what I say in the skeleton, what we say in the skeleton about that is that it's wrong to draw a distinction between state of mind, the effect on state of mind, and the intention. It's all part of the formulation of the intention to take her own life. So if there is a depressive exacerbating effect on depression, then what he is saying there is that would that have affected her state of mind immediately before her death? Yes, she would have had one of these exacerbated reactions. That is highly relevant to the question of whether she intended to take her own life.
But it might be a number of things, you see. If Jodie had not had any history of mental health and the benefits were cut without notice in effect, she may have committed suicide. But in this case, there may be an interaction of a number of factors. There's the underlying health condition, which magnifies difficulties. There's the chronic pain. Don't forget, she was in chronic pain for a whole variety of other things. There were things going on in her family which we don't need to go into, but there were a lot of things there. And it may perhaps not be correct to say she got this letter, couldn't cope anymore, and killed herself. And she got this letter. She already had these underlying problems. They magnified and made this much worse. And together, everything coming on top of one another, she couldn't cope.
Indeed.
You know, we just don't know. And I'm not saying that's what happened.
No, we don't know, but that does open the possibility for the coroner to make findings to that effect.
Well, you say that means a material contribution to the state of mind leading up to
Indeed.
suicide. Yep, sorry.
May I try and address ground one? The way I propose to try and do this is to state a series of propositions, taking the skeleton rather than read it out, and then give you some authorities which support them. The first point is that we say the fresh evidence gives rise to a concern that the cessation of benefits was of direct causal relevance, and whether that's trigger or material contribution, and may result in an enhanced narrative conclusion with factual findings. That's the first proposition. We say that essentially in paragraph 12.
Hold on, yeah.
Mr. Ham, can I just go back a step? I meant to ask you something and I failed to. Can we just dwell on factual findings, just so that we can complete what we were talking about before? If the coroner were to accept your invitation to do a narrative verdict, that would have to be based on factual findings, I think, that you'd put somewhere else. I'm not quite sure which box they go into. Would it be a factual finding on your hypothesis that there was a material contribution? Is that a fact finding, that there was a material contribution by the cessation of benefits that therefore contributed to state of health? That's all part of the facts.
It's a fact.
And it's an inference you'd be asking the coroner to draw based on such evidence as was.
Indeed. It's a factual finding, not an expression of opinion. It's a factual finding on the evidence that on the balance of probabilities I find as a fact that there was a material that the cessation of benefits materially contributed to the decision and the intention to take her own life. That would be a factual finding that would be capable of being, should be recorded for the reasons I showed. Once you've looked at whether the balance of her mind was disturbed, you've got some evidence that it was and you've heard the evidence and you accept that evidence on the balance of probabilities, then you should record it as a fact, as part of your factual finding. Is what I say. The next proposition, I'm giving a footnote as to where you find this in the skeleton, so paragraph 13, is that it's permissible to do so in our case without a replication. And you've seen me refer to the sort of Norfolk coroner case about replication, and I hope I've made it clear that we're not seeking a wide-ranging inquest where every witness and every person who answered the telephone is called, because those findings, in fact, have already been investigated and made.
That is a significant difference, isn't it, from the way the case was run below, where it seems that there was a much wider inquiry.
It is a difference from how it was run below, but it is, and to some extent, it may be that the Divisional Court were concerned about the extensive inquest that was being suggested, and saying, well, this just sounds like a completely unnecessary waste of resources when this has already been comprehensively investigated. You see Justice Warby's comment about there's sufficient public notice of the ICE finding. It's a sort of publicly available document. If it needs sufficiently publicly available, why should it need to be done? Our case is that a narrower approach is the proper approach, given the authorities and given the Norfolk case. That doesn't mean that the scope is necessarily narrow. It just means that the way in which evidence is adduced is narrower than it would be. So, as I explained, a DWP representative would be able to speak to the policies and so on that were available and confirm the findings of the ICE report.
Why would that be necessary? I mean, if all you're asking, what are your policies? Well, we know what their policies were because they ignored them. And what are the findings of the ICE report? Well, there they are. What are you going to gain from having the DWP?
Well, I think
giving evidence, presumably, but via some official who has no immediate knowledge of this case.
Well, very much as in the person who replied to that Freedom of Information request and said, well, these are the policies we have. We've got the vulnerable persons and we've got the declaration of, and they could be produced effectively for the coroner. And that person, really, their role at the inquest would be to produce the relevant documents, confirm their truth, and be available if the coroner had questions about those documents, those policies, or about their application. But it wouldn't be a question. That is mainly a way of just getting the evidence before the coroner.
That's what I was troubled about. There are different sorts of evidence. The first set of facts that we need to know is what happened about the benefits. Did they ask CHDE to consider a home visit? Did they make a telephone call and so on? As I understand it, and that's what I asked, the facts, the primary facts, who did what on what day, are set out in the report. And as I understand it, the DWP does not contest that is an actual factual finding. So the factual set of circumstances are known. So you're not going to have an inquest into did they or did they not telephone Jodie, because the fact is they didn't telephone Jodie and they've accepted that. And that's a key thing in terms of the thing. Thereafter, there is documentary evidence, which could be the policies, but again, they're annexed, we refer to them, to the report, and so on. So one would be a matter for the coroner, if there is another inquest, the coroner would need to go beyond what's there.
I agree. And they could be admitted under Rule 23 as documents, and the coroner could just simply take them into account.
The coroner may say, I don't need to have that taken into account because I've got facts that have been admitted in the coroner's report that they should have made a home phone call and they didn't make a home phone call and they didn't consider a visit to find out why Jodie hadn't attended the work assessment. So all of that may be done, and those facts, what happened and so on, and should something else have happened, is in the report. The next question is, and in a sense, the failings don't matter. What happened to Jodie was her benefits were cut off and she didn't know where to turn. And the question then is the connection between the stopping of the benefits and Jodie's mental health.
Indeed.
And that isn't something the DWP
can shed any light on it all.
So I'm sometimes concerned that having said below and having said to us the opposite, that this is not an inquiry into departmental failings, that there are sometimes hints that the intention is, and I'm just seeking clarification, really. If you follow me.
Well, how can I address it? This is the best way of addressing, I think, is the question that's posed. If there are fresh inquests ordered, a coroner will have a discretion as to the scope of that inquest and the evidence or the witnesses the coroner wants to hear from in relation to it. The coroner will read the underlying information, the ICE report, the policies if they're produced. The coroner may, as a matter of discretion, decide to accept that evidence as simply as documentary evidence under Rule 23, I think it is, and it can either be read in or taken into account by the coroner in that way and referred to, or various passages read out in the course of the inquest. On that scenario, the role of the DWP is very limited indeed, save in the comparison hospital case that I give, the person who says, well, yes, this happened. I'm here really just to say that since this happened, we've done X, Y, and Z, and to try and learn from it and improve our systems, and we've got this, that, and the other in place. And that evidence is really a matter for the DWP, but the purpose of it is usually to encourage the coroner that there's no reason to write a PFD report of any kind.
Could the coroner require the DWP to attend and address that issue?
Yes.
They could. So, although it's the role of the DWP, the coroner himself or herself will have to decide, 1, the primary facts, how am I going to deal with that, 2, the documentary policies, and 3, the response.
Yes.
I mean, these are all case management decisions for the coroner.
Indeed.
And in a sense, you're digging a hole for yourself that you don't need to, because if the coroner decides I can deal with this, the DWP side of it all on the papers, well, fine. You still have your point to make, predominantly based on Dr. Turner.
Predominantly, exactly. But I was asked to clarify, and the reason it's quite difficult to give total clarity is because the scope of inquest is a discretionary decision for the coroner, and what witnesses the coroner thinks he or she wants to hear from is a matter for them. But I accept that within the range of discretionary decisions, a discretionary decision to say, well, I'm simply going to accept the ICE report and the documents as documents.
Well, the parties can agree that the facts recorded there are accurate. It's the
because
facts
of the agreement.
report.
Yeah.
If the DWP doesn't accept the facts, then there would have to be an inquest into the facts. But the reason why I ask this is because we've got to see whether the court below was wrong, and the court below said the coroner didn't think she needed to investigate the DWP, and they found that was open to her, and we'd have to be satisfied they were wrong. But if there's another way of looking at it, i.e. there's fresh evidence now, but the fresh evidence is not so much the failings of the department, we know about those, but the link between the failings, or the cutting off of the benefits, and Jodie's mental health, that's the thing that's not been looked at before, if you follow me.
Well, that is our case. The coroner, first time round, didn't know about the failings, didn't know about the timings, didn't know about any of the matters that we now learn.
And didn't have Dr. Turner's evidence.
ICE report.
And didn't have Dr.
And
Turner's
didn't have Dr.
evidence.
Turner's
That's the key thing, because Mrs. Dove was telling the coroner, and the children were telling the coroner, it pushed her over the edge. They showed her the text messages. But you say I keep saying the link, it's the connection, to use the neutral word, between the mental state and the cessation of benefits, and that is there now because of Turner, you say.
Can I try and express it as simply as I can? The Divisional Court were wrong because in their minds they were concerned that, and were satisfied that there was no reason that the coroner should have to reinvestigate the failings. And we agree, there is no need to reinvestigate failings.
Yep.
But where they went wrong was to misunderstand that it isn't just failings, the failings that needed to be investigated. the failings are admitted. It's the causal connection between and then, both in time and psychological effect of the decisions that were product of those failings, by which I mean, as your Lordship has identified, the cessation of benefits, the phone call, and the timing of those events. That, the causal link, whether there is a causal link between those matters and the death, has never been investigated. And that is what we say, I think it's what we say in the skeleton, and it is the error that was made by the court in that regard.
And that's not, just picking up, I think, where the Divisional Court was, and finishing off your thought process, if I may, as I've understood it, the case is that it's not, that the investigation requires thought, analysis and decision, whichever way. It's not enough just to say mum says that she thinks her daughter was adversely affected by the cessation of benefits. That's just to record evidence. That's neither here nor there. But that's where Dr. Turner gives you an objective additional element that you want to kind of think about.
You know, to enable a finding, one way or the other, whether there is a causal contribution. And it's that ability to make a finding of real value, frankly, whatever the outcome is of that further inquest, whatever that finding is, it's of value because there's been investigation as to the extent to which, if at all, it was a causal contribution. If the conclusion is it was a causal contribution, then that's...
Yeah. Just one thing to make absolutely clear, Mrs. Dove's evidence, because she knew her daughter and she'd been with her daughter right up to her daughter's death. Her evidence is evidence which the coroner could have accepted or not accepted. We're not saying that Mrs. Dove's evidence is something to be put to one side unless you've got a doctor who doesn't matter. What we're saying is the coroner didn't decide whether she accepted Mrs. Dove's evidence or not. She recorded it and said, yes, this is what Mrs. Dove is saying. So when the coroner, if there was another interest, comes back to it, the coroner would still have to listen to what Mrs. Dove said, because Mrs. Dove was her mother and she was there with her and she knew what she was saying. She knew what was preying on her mind in the days before her death. And also, there'd be possibly other evidence in the form of Dr. Turner. So I don't want Mrs. Dove to think what she said was irrelevant. It's evidence of what Jodie was saying and thinking in the days, sadly, up until her death.
My Lord, I completely agree. I mean, and Lady Justice Whipple also identified the difference between recording a belief, the belief, and some sort of objective finding or objective corroboration that belief was justified.
Well, you may say that if it goes back to a coroner and she reads Turner, she'll say, yeah, Mrs. Dove was right all along. That's something the coroner can decide to do.
Well, that's what my Lord, yes.
Anyway, we've got that. I didn't want Mrs. Dove to think her evidence was being ignored. It's not being ignored in the slightest, because you were there.
Thank you very much. I think I've already sought to point out that we do draw a distinction between state of mind and the death, and we've explained that that's we think a species distinction and material contribution comes in. I'm not going to repeat that point. The allied point is that there is a prejudgment on the issue that falls to be investigated. That is a criticism of the Divisional Court. The essential reasoning is that they've read Dr. Turner and said, well, that's never going to prove causal link, therefore there's no purpose in having an inquest. So that and it comes back to the point already identified in argument. It's not the failings, it's the linkage between the cessation of benefits and the death. That has not been investigated, and you can't prejudge what the outcome of that will be in the light of the fresh evidence. The fifth proposition in my skeleton address at paragraphs 19 to 21 is an impermissibly narrow approach to the findings that may be made. And you may have seen that in our skeleton we put forward some suggested wording which does not contain judgmental findings or opinion. And what we understand the Assistant Coroner's response to be is not to say that that wording is impermissible. The way it's responded to by the Assistant Coroner at paragraph 26. D. Is, we say this response 26D is shooting at the wrong target, because what it says is, and I'm at page 17 of the Assistant Coroner's Skeleton, paragraph 26D, if the appellant's point is that a second inquest should be ordered so that a conclusion can be expressed which states that the failures caused or contributed to Miss Whiting's death, then the coroner would respond that the conclusion of Jameson must be brief, neutral and factual, no dispute with that, expressing no judgment or opinion, no dispute with that, it's about factual findings, which would not allow for a conclusion criticising the DWP. We're not asking for a conclusion criticising the DWP. We're asking for factual findings as the causal nexus between the cessation of benefits and death. And we say in relation to the legal point that is addressed, what is then also said, if I may stay in that skeleton, is, now in page 19 of this skeleton, paragraph 27D for Delta, reads as follows: while a coroner's inquest into an apparent death by suicide may receive evidence about the deceased's state of mind, so Dr. Turner, Joy Dove, most obvious to establish whether or not there was a suicidal intent, it is not essential for a conventional inquest. Now, if the point's been made, it's not necessarily the case that there must be, we agree. But I think by using those words, the Assistant Coroner is acknowledging that it is well within the discretion and the ability of the coroner, as indeed I've shown you the coroner's guidance notes, to reach a conclusion, non-judgmental, expressing briefly the factual findings on the key issues which were the focus of the inquest. So as we understand the first respondent's skeleton, they're not seeking to support the position that the finding that we are seeking is impossible or not open to the coroner. And the reason I put it in that way is you may have seen that Lord Justice Warby's analysis, he concludes with turn up the paragraph. I think it's 100. We're addressing here paragraph 100, page 128 of the core bundle. We say Lord Justice Warby is here wrong to say, final 4 lines of paragraph 100, Dr. Turner's report links the department's errors with the stress that she was clearly suffering, but it would not support a finding that the department was responsible for that decision. Pause there. I'm pausing there. I don't want to be. I want to be clear that this is a case where Article 2 was being run in conjunction. So words about responsibility and state responsibility for particular decisions were in play in the decision.
99 and 100. He's talking about the Jameson inquiry. It's over the page, really.
Yeah.
This is just Jameson.
It is just Jameson, but in fairness to Lord Justice Warby, this is a case where Article 2 is being run in conjunction, and words such as responsible may have connotations of state responsibility. That's all I'm saying, because Dr. Turner's evidence does, on its face, support a finding that there is a causal link, a material contribution, certainly arguably so. So it would be wrong for Lord Justice Warby to say it would not or could not support a finding that there was causal attribution in the sense, if that's what he means by responsible, for that decision. Assuming such a finding would be open to coroner as a matter of law. Well, if it's being argued that it isn't open to a coroner as a matter of law to do that, we say, well, that's clearly wrong, because we've seen the coroner's guidance, we've seen that findings are open to the coroner to record findings of fact relevant to the decision.
I read that passage in the following way, and I may be wrong in reading it in this way, so if I am, you'll tell me. I read him, you've got to read the bottom of 99 and the whole of 100, and he's giving reasons why he didn't think it was necessary or desirable for an inquest. And there's no doubt that he sees a link between Dr. Turner's evidence and the mental state, Jodie's mental state. And I think the last two lines are his saying, but the argument that appears to be run below, that the reason why she committed suicide was because the benefits were stopped, wouldn't be supported by Dr. Turner. And that's what we've been discussing throughout, because I've been saying there's a lot going on in Jodie's life. It's more complex than that. There's personality disorder, there's the chronic health conditions, there are the other family factors, and then there's this. And taking them together, they're things that fed into a mental state, which then led to the suicide decision. So he's disagreeing with some of your paragraphs where you say Jodie committed suicide because the benefits were stopped. Put as simply as that, and that's not what Dr. Turner is saying. But you would say, not that he's wrong, but that he's not looking at all the picture, because other things, such as linkage with the other factors, is itself a fact to do with the reasons why Jodie died.
My Lord, I think in fairness, in order to defend our scale, I think our approach is to say too narrow.
Too narrow rather than wrong.
Too narrow than wrong.
Yeah. And that's enough for you, you say, yeah.
My Lord,
And
yes.
too narrow, so can you please go over that? Because I'm not sure I quite got that. I had read this last sentence, and I was troubled by it as looking for responsibility for the decision to commit suicide, which felt to me wrong in two respects. One, that you're, well, sort of the same thing, but it was looking for causation, not in a material contribution sense, but just did A cause B in a linear sense, a but-for sense, which isn't right. And it was also conflating it was drawing what I think you call the forced distinction between a deteriorating mental state on the one hand and committing suicide by your own hand, sort of like something separate, where I think your invitation to us is to look at it as all part and parcel of the same thing. So can you just run me through the narrowness, not wrongness submission again?
My narrowness answer was a response to my...
But I think you said it was
Lord
how
Justice
your
Lewis
skeleton
explaining that a reading of it. My read. Well, can I just start again? My reading of that is that it contains at least potentially two internal errors, as just identified by Justice Whipple. First, that it's looking for a direct cause rather than a material contribution, which isn't right. And second, that such a finding would not be open as a matter of law, which is not right either. So that's my case. Those are wrong. But if all that is being said is no, what he's really saying is he's just looking at the narrow question, the narrow question of can you attribute causal responsibility against of this event against a background of many other potential causes. Then it's too narrow, I suppose, because I say that doesn't take into account the whole picture, and we're back really to material contribution, I think, on that point.
I think so. If you look at 99 and 100 together, 99, the authorities indicate that when addressing the how question, a coroner may, as a matter of discretion, go beyond a bare determination of the mechanism of death, but limited by statute, can't go into civil or criminal liability, or expressing matters on surgeon's opinion. when the discretion is available, governed by public interest, the coroner took the view that the public interest didn't require her to investigate the role of the department. The reasons given by Farby J. that was not wrong. What the coroner did was decide that she had sufficient to satisfy the requirements of a Jameson coroner's inquest. And then he goes on to say the fresh evidence doesn't alter that. And he's saying why the fresh evidence doesn't alter that. Yeah. And he's saying it doesn't alter that because there's been an investigation, so we know what happened now, multiple failings. We know what they are. They're not disputed. So you don't need the inquest for that. He doesn't think it's necessary for publicity terms because we all know what the ICI report does. And then he's turning to, does the other report, the Dr. Turner report, change the position? And he says no, because although it contributes to the suffering, the stress, it wouldn't support a finding that the department was responsible for the decision. And that's why I took him to be saying, you can't say that but for the cessation of benefits, Jodie would have died. But if that's the wrong question, and you should be saying, well, even if Dr. Turner wouldn't support a but for, but Dr. Turner would support, there were a lot of things here, underlying mental health condition, pain, and it made the shock of the benefits being cut off even worse, then that's a different exercise. That's why I read 99 and 100 as I did.
I'm sorry, the matter is, in my submission, now clear.
Yeah.
The error is the but for.
Yeah.
Rather than a wider causation question incorporating material contribution.
Yeah. Your first point and the way that I put it are the same, actually, I think, in different ways.
And I repeat my point, as a matter of law, it's entirely open to the coroner to make a factual finding of materially contributing factors.
Does that, you may be coming to it, and I don't want to take you out of sequence, but somewhere in here, oh yes, it's the last line in paragraph 99. Do you, at this point in this court, challenge Lord Justice Warby's statement that what this coroner did was, on the evidence she had, sufficient to satisfy the requirements for coronial investigation of the Jameson variety?
No, I do not challenge that.
You don't challenge that?
I don't challenge
that. So we accept that it, in terms of what went before, it was...
Yeah, this is a fresh evidence.
Just fresh evidence.
This isn't a judicial review of a scope decision.
No,
there was discretion for the coroner. Sufficiency of inquiry was a matter for the coroner. She had very little. She didn't have Turner and she didn't have the ICE report.
So the... Yeah, okay, thank you.
Thank you. I think I've covered it, but in our skeleton at paragraph 23, we identify what we say is a submission of the assistant coroner. It was made to the court below, but appears to have been accepted. Our submission before this court is to say, even to the extent that the assistant coroner seeks to say that the content of that submission is correct in law, we strongly disagree for reasons we've been over. But on the underlying matters, the determination at the end of a second would be limited to the means of death.
Sorry, I've lost. Sorry, my fault. I've lost where you are.
The argument.
Which page are you?
Sorry, could I take you to my skeleton at page 9, paragraph 23.
Yeah, thank you. I've got that.
Page 11 of the core bundle.
I've got that. Yeah.
The submission we made was that the court appeared to have been heavily influenced by the following submission, in part of its submission below. The determination at the end of a second inquest would be limited to the means of death. That's stating Jameson. Accordingly, it would have to be a conclusion of suicide. Pause there. Not necessarily, it could be a narrative verdict alone, and there's no requirement to use the official list wording. and no narrative addressing any failures could be given. Well, we accept no failures, but we say a narrative could be given addressing findings of fact. And then running one's eye down, it could not go into underlying and contributory causes. Is I've underlined? Yes, it could. And Longfield shows that clearly. And I'm going to take you to the authorities to make good that proposition. I've already finished my sort of summary submission on the propositions of why we say it went wrong, adopting what I've said in the skeleton. Can I just make those points good by reference to section 13 and 4 authorities? The first, if I may, just on section 13, there's in fact no quibble with the approach to the question. That is to say, it's, I think paragraph 10 of South Yorkshire is cited in the decision. But just to see the evolution of section 13 in some of the cases, there's Lord Justice Moses' decision in Sutovich, which is to be found at page 247 of the authorities bundle. 14, I think. This is a sad and quite complicated case because there are a large number of experts arrayed by or purchased effectively by the grieving mother of the deceased as to how the deceased came by his death. And there was a suspicion that there may have been some foul play or some violence in advance. And just to note, if I may, that there was both a judicial review and a section 13 application, and that at paragraph 52, the judicial review claim fell flat on scope and insufficiency of the inquiry, and you see how flat it fell with the wording at the end of paragraph 52 on our page 260. They don't afford the basis for any relief. Indeed, in the light of the section 13 proceedings, it seems to us they should not have been pursued. They were, in the light of those proceedings, pointless. So a different approach between judicial review and the fresh evidence. The fresh evidence application was made on the basis of the cumulative effect of a number of witnesses, I think 9 in number. I'm certainly not going to go through the detail of the various things they said and some of the criticisms that were made of them by the court in reviewing that evidence. And you can see paragraph 93 that I think Lord Justice Moses had cause to make some harsh comments about some of that evidence. The ultimate decision was that there should be a fresh inquest. There was no suggestion that this was a Article 2 inquest. The approach to the inquest is, or fresh evidence is, which I rely on, is paragraph 54, and the power under 13(1)(b), and its broad terms, necessary or desirable. Notwithstanding the width of the statutory word, its exercise by the court shows that the facts of central importance are an assessment of the possibility as opposed to the probability of a different verdict, and the number of shortcomings and the need to investigate matters raised by the new evidence which have not been investigated and their recite. So that's the approach. We see that picked up in the other cases.
Can I just be clear? As I'd understood from what you said at the beginning, in terms of the verdict of suicide, it's accepted, sadly, that that's what happened. And the question is, what led up to that, rather than this case, which is, they said that he died of natural causes.
A different.
It was a drug he was a drug addict, but in fact there was evidence that somebody had beaten his face, so that it was said to be
Yeah.
murder versus accidental or open verdict.
Well,
We're not into that here.
Well, it is accepted that on the basis of the evidence of the note and what she'd been saying, that on the balance of probability she took her own life and intended to do so. But it's very much Joy Dove's case that that formulation, that intention was causally related to the cessation of benefits. And the point which I'm helpfully prompted to make is that a narrative conclusion is a different conclusion to a conclusion of suicide. If that's not clear, I'll try and make the point clearer.
So looking at the form that you showed us, are you saying that it's possible in this case, because I thought you weren't saying that at the end, just to see it in visual terms, I thought you wanted things in box 3 added, how, when and where, to explain the set of circumstances which affected the mental state which led to the suicide. Yeah. But I didn't think that you were trying to change the conclusion. But are you now?
I've not made myself clear, because our position is that I maybe went too fast over it. I think our position is that the guidance as to the approach to completion of those boxes, if I may go back to 13-26 of Jarvis.
Yeah.
Paragraph 4 sets out the conclusion of the coroner as to the death. The conclusion may be one of the short form conclusions, so it could be suicide, or a narrative conclusion. A narrative conclusion may also be used in addition to a short form conclusion, so that's another alternative. A narrative conclusion in paragraph 4 may also refer back to the facts found on the how, when and where questions are set out in paragraph 3, but the better way to record the mechanism of death is in paragraph 3 and the wider but brief narrative in paragraph 4. So putting that together, a fresh coroner, armed with the evidence that a fresh coroner might hear, would be able to, following this guidance, which is the guidance that appears in the Chief Coroner's Guidance, in box 4, where you currently have the word suicide, a narrative conclusion that refers back to the mechanism entered into box 3. That's the preferred way of doing it according to the Chief Coroner. It is possible, not the preferred way, of putting the how, the narrative, in 3 and combining it with a short form conclusion in 4. That is possible. But the point I'm trying to make is we do not... the conclusion simply suicide full stop is not the conclusion, or not a conclusion necessarily that the coroner will reach all that would be advocated at the end. The likely submission at the end of evidence such as this would be, having regard to guidance note 17, is, coroner, we think you should enter a narrative conclusion after the matters you've explored at this inquest, reflecting the facts that you found in relation to death, and we think a narrative would do justice to what you've heard. And the coroner may then, in his or her discretion, follow that procedure, and in box 3, put in the mechanism, in box 4, put in a short narrative, a handful of words, and we've given some sort of wording that might be included. So we are saying that a different conclusion may
differently worded and expressed conclusion, which includes more than suicide.
Indeed.
But it's not suggested that the word suicide is removed, because...
Well, it's not necessary to use, so it could be used. We're not saying it would be impermissible to use the word suicide, but there's no official list. A different, she took her own life, could be used, for example,
Yeah, I see, right. Yeah.
in circumstances where her depressive state was aggravated or exacerbated by the abrupt cessation of benefits just a few days, weeks before.
Yeah.
I'm invited. I think I will. May I take you to the form itself?
Mm. I've got 3117 open in front of me.
I think we've Can I give it to you in the? It's at the back of the coroner's guidance.
Yeah.
So in the authorities bundle at 1218, right at the back of our bundles. It's yes, and I'm helpfully reminded that it's appended to the rules themselves. This isn't just a piece of guidance. This is part of the
rules. Yeah.
rules. And you see under the notes, after the official, what's referred to in Jarvis as the official list 1 to 9, in Roman 2, as an alternative or in addition to one of the short form conclusions, the coroner, where applicable, may make a brief narrative conclusion. So the options are open, as I've indicated from this.
Yeah.
May I just take you to what I was in Stutovich actually, and the reason I do is because while we're in it, just to pick up, there's a mention of, just to make sure we've understood that between 96 and 98, it's made clear that we're talking about Jameson Inquest, because it's made expressly clear by Lord Justice Moses this is not a case to which Article 2 applies, at 96 on Authorities Bundle, page 270, and right at the bottom of 98, right at the bottom of that page, the final words on the page, even absent the requirements of Article 2, the function of inquest is to seek out and record as many of the facts concerning the death as the public interest requires, and then goes on and deals with, that's particularly important in the case of an open verdict. So next case, Davison, that's a recent case, our bundle, I think tab 45, Bundle 2 of the authorities, page 1190. A decision of Lord Justice Holroyd and Mr. Justice Garnham, 2022, so recent. Facts summarised in para 1 that Megan Davison had the misfortune to suffer from type 1 diabetes and diabulimia, a psychiatric disorder which involves deliberate omission of insulin doses, who took her own life in 2017, aged just 27. The death was recorded as a suicide, no prevention of future death report. Fiat was made on the basis of fresh evidence, in particular evidence of an expert witness as to the nature of diabulimia, and that was one of the bases of the attack, or the reason for a fresh inquest. You see at paragraph 13, this expert, Professor Ismail, the details of what he reported are summarised in paragraph 12, and at paragraph 13, including, I should say, that there's no routine screening for it. The mortality rate for it as a condition is unacceptably high. In other words, it wasn't an extremely rare condition. It was a bit more common than the coroner had understood. And Professor Ismet 13 made some criticisms and said that there was value in a new inquest in increasing the understanding and nature and incidence of diabulimia, which could lead to more screening and assessment of patients and so reduce the numbers of deaths. So a PFD report, public awareness of the problem being relevant. A legal framework recited, section 13. Sutovich, paragraph 54 recited, we've just been there. 17, Attorney General and Coroner for South Yorkshire West. This is paragraph 10 of that decision, which is cited by the Divisional Court in the present case. There's no issue with this description of the test. The single question is whether the interests of justice make a further inquest either necessary or desirable. I'm not going to read the rest of the paragraph. I just invite your lordships and ladyship to read that. Detail of the matters to be ascertained. Well, we've got those. Some 18. Coroner's rule about written evidence at Rule 23. Grounds of the application summarised at paragraph 23. Point 1. Professor Ismail's report is important new evidence enabling the circumstance of the death to be explored more fully than it was at the inquest. At a fresh inquest, the coroner will be invited also to call order from Ms. Harris and other members of the SEDS team so that both the care given to Megan and the systemic issues raised by him could be explored. It's at least possible that a fresh inquest would lead to a PFD report, in particular because of the systemic issues, etc., and then going on a number of grounds, 1 to 9. I'm not going to go through them all because we'll see how the court analysed them and responded to them. Analysis at starting at paragraph 29. The view was that the coroner had proceeded on the basis that diabulimia, this is the first 3 lines of 29, was a rare condition, and in fact, more worrying, it is a more widespread disorder than is commonly recognised. There should be a better coordination between different disciplines, and certain red flags were not acted upon. And these features of the report have obvious implications for any consideration of the nature and standard of care which you received and whether a PFD is appropriate. So it adds important information that casts a different light on other evidence which is appropriate to be considered, and therefore says that new evidence is necessary or desirable for a fresh investigation to be held. So by itself that was sufficient. But then goes on to say, the court goes on to say, that some of the other grounds were accepted, and at 32, fresh inquiries would lead to a PFD report, and we say, yes, that's this case also.
Well, 32, you've got to read the opening sentence. On the basis that the first ground succeeds, we also accept, at least to some extent, a number of other grounds which would not have caused us to direct a fresh investigation if it did not be for the new evidence.
Yeah. No,
so there's got to be the new evidence before you get to that. But you say you've got the new evidence.
Yeah, I've got the new evidence. Yeah, sorry. And I appreciate that's what I said, but I think I understood the court to be saying there, look, you're getting nowhere with that argument. But on the fresh evidence ground, yes, you do. The fresh evidence may lead to a PFD report. At 33, there's a public interest in more being known about the dangers of diabulimia. We say public interest in more being known about the risks of cessation of benefits on the vulnerable. The concerns, and this is true also in our case, thirdly, the concerns and wishes of, one could just substitute, a Joy Dove's family, carry an additional weight which they would not have had without the fresh evidence. This is the point about belief state and external corroboration. There's a point about Rule 33 doesn't apply. Paragraph 36, the availability of new evidence may result in a different view being taken as to whether any act or omission in the care may have contributed to her death. Well, that's our material contribution, whether, for example, the cessation of benefits may have contributed to death. So it'll be up to the coroner to decide that. And it is at least paragraph 37, it's at least possible that a different and more detailed narrative conclusion will be recorded. Well, again, we say the same here. And in those circumstances, our case is very much that all those or similar reasoning can apply to our case, and the necessary or desirable threshold is crossed. And insofar as the court concluded that it was neither necessary nor desirable, it was based on an error as to either the need for direct causal proof or, put another way, a too narrow approach to the question of causation. Longfield, I said I'd touch on just to give the example of the narrative decision of Mr. Justice Mitting. It's at tab 10, page 126 of our authorities bundle. It is, and I'm just going to say this without turning it up, it is footnoted to the Chief Coroner's Guidance Note 17 as authority for the proposition that narrative conclusions are particularly useful where there's more than one cause. And I'm not going to necessarily take you to that, but it's footnoted, so approved essentially. And the head note tells you what the case is about, 126. Deceased, suffered with dementia, resident of the care home, fell through a lounge window, which had been left open by a staff member, sustained non-life-threatening fracture of the arm. She died in hospital 19 hours later. The uncontested evidence was that she'd been suffering with bronchopneumonia, which would have caused her death in spite of the fall. So you had an underlying condition which may have produced a particular consequence, namely her death. There was an issue about sufficiency of evidence, and misdirection as to neglect, which I don't trouble with. I see from the appearances that Mr. Hoff was instructed in that case on behalf of the coroner, and we see that the relevant reasoning in relation to the approach is, and what verdict is or is not open, is to be found within that authority. If I could pick up at 133. A simple verdict of death by natural cause or accidental death is inadequate to describe that which the jury truly found, but a remedy is at hand, and the coroner is not to be criticised for failing to apply it. Refers to Middleton and Article 2, and in particular the paragraphs 35 to 37 of Lord Bingham's speech in that case about the change of approach, and in particular what is said about in paragraph 37. And the important distinction drawn within paragraph 37 of Lord Bingham's speech between factual conclusions and opinions and expressions suggestive of civil liability, and concludes at 31. In cases where the death results from more than one cause of different types, a narrative verdict will often be required. It is here. The jury's findings can be encapsulated by a verdict such as the following. I read out my proposed text, invite counsel's views. Mrs. Hall died of bronchopneumonia resulting from dementia. Her death was probably accelerated by a short time by the effect on her pneumonia of injuries sustained when she fell through an unattended open window which lacked an opening restriction in the lounge Longfield care home. So that's there as the example, referred to the coroner's guidance, of where two different causes, one that may accelerate an underlying condition or exacerbate an underlying condition, is perfectly proper to record by way of a narrative verdict in a Jameson inquest. And I say we're on all fours with that in terms of the verdicts that are open or the conclusions that are open to a fresh coroner. Finally, I think in my summation of cases relevant to this ground, if I may deal with Worthington. And I've mentioned that to some extent the facts of this case, may I just take it to you briefly. It's to be found at tab 34, page 859 of our authority bundle. Page, 859 is the front page. The text begins at 861. And paragraph 2 summarises the facts. And there have been acute injuries to this poor child's, 30-month-old child's anus and rectum. And a key issue was whether Poppy had been anally penetrated in the hours before her death, and if so, whether that was causally relevant to her death. So that was, there was an act or omission. Was it causally relevant to the death? There was a long review of the case. At paragraph 12, common ground that Article 2 is not engaged. A review of the terms of Section 10, and then this from Lord Justice Higginbottom. I'm reading from just above paragraph 14, the indented paragraph. Therefore, Section 10, determination refers to a determination of the matters required to be ascertained, including Section 5.2 if it applies, and findings refers to findings as to the particulars required for registration. In this claim, we are not concerned with findings as to registration particulars, only the determination of matters to be ascertained under Section 5A and B, especially how Poppy came by her death. So findings relevant to causations, not opinions, but findings on the balance of probability. The approach to the coronial task summarised at paragraph 17 by reference once again to the Chief Coroner's three-stage guidance. And the key issue, paragraph 25, page 867, or a significant issue at the inquest was whether the claimant had sexually assaulted Poppy prior to her death, and if so, whether that caused or contributed to it. And then that was dealt with, as you can see, in some of the factual findings by the coroner, in particular at 140. At paragraph 26, there's a summary of the coroner's conclusions as to cause of death. She lived for some time after the act of assault and concluded that it was not a cause of death. Rather, he concluded that she died from asphyxia resulting from the obstruction of her airways while she was asleep. And the whole thrust of Leslie Thomas's argument, the claimant's argument acting on behalf of the father, was to say, I want that struck out because it's not relevant to the finding recorded against the father. That, and you can see it in box 3, italicised in paragraph 29. In the box 3, those were the words that were being sought to be removed as being said unlawfully entered into the inquest or into the inquisition or record of inquest. And refusing to remove those words, the reasoning begins at 34, rejecting the distinction between the findings of facts and the determination of how Poppy came by her death. Paragraphs 147, 148, as well as box 3, he submitted fell within the determination, and that distinction wasn't accepted. The three-stage approach is then summarised. The approach was adopted and confirmed as appropriate by the court in paragraph 36. They were unimpeachable, the content of those criticisms. and the focus on the record of inquest at paragraph 37. No error, paragraph 38, by the coroner in recording a finding of the penetration in his determination, whether viewed as restricted to box 3 or as extending paragraphs 14748. None, and the reason why none of the references compromises section 5.3 because none expresses an opinion. The reference repeat a finding of fact. This is the point about findings of fact. It's the causation that we've already discussed, made in the earlier review. It's not an opinion, it's a finding of fact. And there's no breach of 10 in making a determination of one of the questions mentioned in 5.1a and b, namely how, straying beyond the means by which Poppy came by her death into the wide circumstances. It's a matter of judgment for the coroner. Paragraph 41. And last sentence of paragraph 41, whilst of course it's subject to the statute restrictions in 5.1 and 3, what goes into the determination in respect of how someone came by his or her death requires an exercise of judgment. And then specifically tackling Lord Brown's speech in Hurst, in particular what is said at 51, but it applies equally to a passage relied on by the HM Assistant Coroner, in this case, paragraph 34, which I'm not going to repeat, but that's the passage relied on. Wording such as Jameson construction how severely circumscribes these, and that's essentially the focus of that passage. And the court's response is to say Lord Brown was here merely emphasising that where Article 2 of the ECHR is engaged, the scope of purpose of an inquiry is wider than if it's not. He clearly does not intend to suggest that no exercise of judgment is required by a coroner in identifying the findings of fact that are deemed necessary for the determination of matters mentioned in 5.1, including how, or the matters that should be recorded within the determination of such matters, and going on to say that the function is to seek out and record as many of the facts as the public interest requires. So our point arising from this is that there is no legal prohibition on the recording of factual findings causally relevant to the death or materially contributing to the death, or, as in this case, it did not cause the death as part of the coroner's entitlement and discretion, having heard the evidence. And therefore we say that this case entirely supports our approach, and to the extent that it said that there's some rule of law that prohibits or would prohibit a future coroner from entering a narrative verdict, entering such findings, we say that submission is unfounded. Indeed, the court went on to agree with the coroner's approach as not being faulted, and they say that at 46, and essentially say that it is not just one that he was entitled to reach, he was, 7 lines down at paragraph 46, right to conclude that it was appropriate to include in box 3 of the record of inquest the fact of the references to the fact of anal penetration in the outside, because it was essential to explain why he was in the unsafe environment, whether which caused the death. So it was entirely appropriate and right to do so. Those really are the authorities I want to refer on ground 1. I had intended to take you to Frost, but really it's a repetition of the principles on approach, repeating South Yorkshire. I don't think there's much to dispute on that, so I'm going to leave that to one side and move to ground 2. And I know, in keeping sort of an eye on the time, but after 10 minutes here, can I give you an overview of the Article 2? Unless you'd like to.
40 minutes, got quarter of an hour.
So good. I haven't got my glasses on this minute. Don't worry. Thank you. Can I move to ground 2?
Yes, certainly. Any questions about 1?
Ground 2. The Article 2 question is whether the circumstances of the death indicate possible state responsibility. that wording a question really derived from Hambleton. The second proposition in this ground is that the approach in Rabone, or Raybone, I'm not sure which is the right way to pronounce it, is to ask a primary question. You can see the court, the House of Lords, do this, or the Supreme Court, do this in Raybone. A primary issue as to the applicability of the operational obligation as a prior question to whether there was real and immediate risk. And you can see that in the judgment. I'll show you that when we look at that case. And the question in our case, as to the, or using the similar approach, would be, can an operational duty under Article 2, sometimes the procedural duty, be owed to a person such as Jodie, who is not detained, but known to be at risk of suicide? And we say the answer to that question will not be a generic one. In other words, there's not going to be, well, for all persons in that general description, there will be a single answer. It all depends on the particular circumstances, is the right approach. It's the approach that we'll see that Lady Hale endorses in Raybone. It's the approach that the courts have repeatedly applied. Now, the appellant says that if those particular circumstances are that the DWP knows of the suicide risk, that's established, D engages in positive acts or omissions. Here, a cessation of benefits is a positive act, an omission is a failure to telephone or arrange home visit, which reasonably foreseeably...
Hold on. Engages in that position. Cessation of benefits or the failure to make the home visit.
Yeah.
Hold on. Yeah.
Well, yeah,
Which reasonably...
My Lord, may I just... I'm reminded... I don't limit myself to say the failure to telephone, but it's the failures are of different kinds, but they include...
Well, the failures individually or together.
Altogether.
Yep.
These positive acts and omissions looked at cumulatively. If those positive acts and or omissions reasonably foreseeably escalate the risk of suicide, and we say that is effectively the evidence, or would be the evidence of Dr. Turner. And D, I say the DWP is the relevant state agency exercising authority and control in respect of the cessation of benefits and has the responsibility for the claimant's welfare when so doing. In other words, what I'm trying to say there is it has responsibility for that risk, the risk so created, the reasonably foreseeable risk so created by the act of omissions. In those circumstances, the positive obligation, the operational obligation applies. And I will reach that conclusion by looking at Raybone, the categories of cases that are there identified, preceding it on a Yildiz, Watts and Mammadov, in particular Mammadov, and the cases that follow it, Kemaloglu, Kent County Council, and the Article 2-3 cases that we've mentioned, Kutupov, I'm not going to go to Limbuela, but the same principle arising from GS and Camden, and one of the other Article 3 cases from the Grand Chamber in MSS in Belgium, where I'll just tell you what they're about, essentially, is about the destitution. If destitution is effectively caused, inhuman, degrading, Article 3, completely without a roof over one's head, left destitute for 4 weeks, that is capable of engaging Article 3. And one of the reasons it does so is because it induces a feeling of total desperation and abandonment in the individual. And the parallel is that the cessation of benefits, total cessation, because she lost housing benefit, the roof over her head, induces a similar feeling of desperation leading to a decision to take her own life. That's Article 3, and we bring those points together by reference to the court's decision in the Palestinian territories case, which is a particular case about, to some extent, benefits, but actually really about a passport or identity, and some of the propositions that can be derived from Gardner, that recent the COVID case that is run. We accept the passages in A.B., Lord Reed's decision. I'll come to it. I'm just going to give you an overview at the moment. That one looks for a clear and constant jurisprudence supporting the incremental by analogy extension. Our submission is on the authorities that I present you, you would expect Strasbourg to agree that the operational obligation was engaged on the particular facts. And when it comes to assumption of the indicia from Raybone, the necessary assumption of responsibility is made out by the positive acts and omissions of the DWP combined with their own safeguarding policies. The vulnerability is clearly made out, and the nature of this particular risk was exceptional rather than ordinary because it was caused or materially contributed by acts that were inappropriate, unlawful, wrong, because those decisions should not have been made as they were. That is the whole thing in an overarching submission. But I'm going to have to break that down into a number of shorter propositions.
There are two questions that have crossed my mind, only because they've crossed my mind, just in case you need to include it, and it's better I tell you now, if you've got the lunch, don't think about it. That appears, that structure that we've written down and we'll think about over the lunch hour, appears not to put, as you said at the start, the question of was there a real immediate risk to life. It puts it differently, and I'm not criticising it, but I'm going to ask myself at some stage, because this is when, do I have to consider if there was a real and immediate risk to life in the way that phrase is used? Right. And if so, what's the evidence on that? Because I've gone through the ICI and I know what, when Jodie went to the crisis team, and I know when they signed her off, and I know that they said she appeared to be managing and stable, but she was walking with the aid of a stick and so on. So I've gone through all of those things in my mind to think, well, what does this show me? So that's one rambling question for you to consider.
It's a perfectly fair one, because I didn't, in my summary, mention real immediate risk, which of course I should have done. Our case is that there undoubtedly was real immediate risk, evidence through the ICE report of risk, real and immediate, present and
Yes.
continuing, in the relevant sense.
Yes, one, what it means in the relevant sense, and two, what's the evidence, because it's something we may or may not have to address. Then the second question, but I think I know what you'll say to this. The next question is, of course, if there is an arguable operational duty owed, therefore there needs to be an investigation to see if that arguable operational duty has been owed. The coroner may be a method of doing that investigation, but can it also be the case that the independent case examiner can do it? Because the independent case examiner has told us what the failings were, and there were multiple failings.
Well, can I answer that by saying our position certainly is that, in truth, the difference between a Jameson inquest, the scope of a Jameson inquest and an Article 2 inquest, should be cigarette paper thin. There should really be no difference to the scope of the inquiry. And the logical consequence of that is that if this is an Article 2 resumed inquest, the scope and the procedure for taking evidence in respect of the DWP failings and adducing them through written evidence being accepted could be entirely appropriate, could be done exactly the same way, and that would follow from the Norfolk coroner case. The difference is when one gets to the conclusion, where it becomes a mandatory duty to record on the coroner the particular circumstances, the how and in what circumstances. And that's part of the duty. Now, if your question is no, that's not what I'm saying, but that's already been done by ICE, so why does the coroner need to do it as well?
Again, yeah, that's the question I was asking. Only as a question, I haven't got a view, yes.
My answer is, it should be done. I'm going to return after lunch to answer whether it must be done.
Yes, that's the question. I know you want it done, but the question is, if it has to be done because there was an operational duty, arguably, has it already been done sufficiently by the independent case examiner who has told us, as I say, the multiple failings? That's the question, really.
Well,
and indeed, I mean, you can't begin to remedy the loss of a life, but they've said this family should be compensated for what they've been through as well. So you've got that as well, but I mean, you can never compensate for loss of a life.
My lord, may I answer them? Must it be done?
Do you want to do it after lunch?
May I do
Yeah, be easier, I think. Okay, yes. That's why I told you now, to give you a chance. I always think it's better to tell you in advance, but
Thank you very much.
I wonder if it doesn't help. Right, well, you've gone through a lot of ground, and we're very, very grateful. Are we on track for...
My lord, we are on track. I, in my time estimate, said 2:45,
Yeah.
and I'm going to stick to that as a cut-off guillotine.
That's great. Well, thank you very, very much. You've been very, very helpful. And everyone just needs to know, don't worry about us asking questions. Lawyers are lawyers. If you put something in front of them, they'll ask a dozen questions. So don't worry about that. We haven't reached any conclusions. We want to understand what everyone is saying, to come to whatever we think is the right decision. So don't worry about that, Mrs. Dove. And if you want a break and you want to leave us alone and want to leave the room, you leave the room for 10-20 minutes if you want a break. Don't you worry about that, okay? Right, well, we'll see you at 2 o'clock then.